Thanks, Emily. So for that reason, we are asking folks to hold questions until the end. If they pop into your mind, feel free to jot them down on a piece of paper or go ahead and pop that into the chat. We'll definitely get to as many questions as we can today live in the program, but we'll also be collecting questions to help inform programs that we'll host in the future. So please don't feel any hesitation. All the questions you have, share them with this. That's really helpful for our conversation moving forward. And with that, I will turn it over to Norah.
Thank you very much. Hi, everybody. My name is Norah Jones. I am an attorney and I'm one of the principals of a boutique firm here in Chicago called C3 Legal. My partners and I spend our entire professional lives representing and working with 501c3 organizations. We work with a pretty even blend of grant-making foundations and operating nonprofits with a small amount of advocacy groups and family offices kind of thrown in there for good measure. But we have, this is the work that we do kind of day in and day out, and that we've been doing for many years together, although it's probably no surprise to anybody to just share that the last 10 months, 9 months of our practice have been really unlike any other period that we've experienced before. There, as you are probably all in the same boat, we go through periods of real stress and crisis, and then brief periods of some calm where you kind of seem to reestablish footing, and then the cycle repeats itself. And one of the takeaways that we are really holding to deeply is that if ever there has been a time for focusing on basic compliance, nuts and bolts compliance and best practice, this is it. We've always been true believers in focusing on best practice and compliance, but the environment in which we find ourselves today really highlights the critical importance of doing that and doing that with some real fidelity. A couple of disclaimers before I share my screen and then kind of dive into the materials is I just want to be candid up front that there is no one size fits all compliance checklist. Every nonprofit is unique. There are some very common threads that run across the sector, and I will absolutely be hitting on those. But each nonprofit organization is a unique business entity, and it has its own unique compliance needs and compliance considerations. So what we're going to be talking about, or what I'm largely going to be talking about today, are some kind of big picture best practices and suggested approaches to thinking about compliance in this environment. Bear in mind that you'll want to take this information and then work with your advisors to really tailor it to your organization so that you are comfortable and confident with your plans moving forward. I'm going to talk for about 40 minutes or so and then leave. And my goal is to leave at least 15 minutes available for questions. As noted, the question section is not going to be recorded. So please do raise questions, but I want to remind you all that this is a very public environment. And so raise questions in a thoughtful, hypothetical manner. You don't want to share confidential or private information that that shouldn't be shared in a large setting like this. All right, so with that, let me share my screen and we will get started. Okay. So pretty ambitious agenda for not a ton of time, but let me walk through it real quick. The first is I want to suggest the compliance goal that we use as our framework. Like I mentioned before, what works as a compliance checklist or a compliance protocol for one organization may not be the right fit for another organization, but in general, I think we can agree on some strategies and some goals that we want when we think about compliance. I then want to give a very brief overview of some key requirements for 501c3 organizations and separately some key considerations for Illinois not-for-profit organizations. we find in our work that that we do it, our clients do it, the sector does it. There's often a lot of combination of the concept of a 501c3 and a not-for-profit, when in reality, they are really two separate bodies of law and two separate regulatory regimes. And again, in this environment that we're in, really being mindful of that separateness and those distinctions is important. I want to talk briefly about the regulatory framework in which we find ourselves today. There's a lot of talk and a lot of concern about risk to nonprofits, risk to 501c3 organizations, but understanding where that risk might be coming from is helpful in thinking through how you proactively want to strategize your compliance goals and your compliance procedures. And then I'll end with some suggested mitigation strategies to help mitigate that risk and ensure compliance. When I think about compliance and what a compliance goal should be for a nonprofit, I think about it in a couple of different ways. The first is, I think you want to know and understand what is expected of your organization. We're going to be talking broad strokes, big themes here, but at the end of the day, each nonprofit needs to go back to basics, go back to its foundational blocks and see, okay, what have we told the government we are? What have we said to the IRS we do and we are organized to do? What have we said to the Illinois Secretary of State about who we are and what rules will apply to us? Really understand what you have held yourself out to the government authorities to be, and understand then what those different filings or statuses mean for your organization in terms of compliance. Be aware of what who the different regulatory bodies are. Understand that you as a nonprofit organization may be subject to regulation by the Internal Revenue Service, by the Illinois Attorney General, by the Illinois Secretary of State, and in a relatively new twist, potentially by the Department of Justice or some other governmental bodies. But know what those regulatory sources are. Once you know that, take a look at your actual operations. Look at how you are operating. What are your policies saying? What are your day-to-day practices like? Are they consistent with what is expected of your organization? Are they consistent with the Illinois Not-for-Profit Corporation Act? Are they consistent with the rules for 501c3 organizations? Especially important in where we sit today, keep monitoring what is happening on a federal, state, and local level. Things are changing rapidly. I will say things are changing rapidly, not as rapidly as some of the dialogue and discussion may suggest, but there still is a lot happening in the nonprofit world right now. And so as leaders of nonprofits, and as part of a good compliance strategy, you want to keep monitoring what those developments are so that you can adjust your plans as appropriate. And that leads into the final compliance goal here, is be in a position that when you know that things are changing and you see what the new expectations are, understand what of your operations, practices, and policies have to be adjusted as appropriate. So again, what this compliance goal, I think the way I've articulated probably makes clear, is that there really is not a one-size-fits-all checklist. Do A, B, and C, and you are fine. This is a much more dynamic, fluid practice that should be baked into your organizational DNA, so that you aren't thrown for a loop if the 501c3 rules change and you're unfamiliar with how to even implement that in your operations and in your documents. Be proactive here and really start again at the basics of knowing what's expected of you, what are you, what's your status, and what does that mean in terms of regulatory obligations. Presumably, most of you on this call are on this call because you are representing an Illinois not-for-profit corporation that also is a 501c3 organization. I realize that may not be true across the board completely. There may be some non-501c3 folks in the room, and there may be some organizations that are not incorporated in Illinois, but by and large, most of you are on this call because you represent or work with an Illinois not-for-profit corporation that also is a 501c3 organization. Your 501c3 status, that is the status that exempts you from federal income tax, and it also is the status that allows donors to get tax deductions for their contributions to you. It is possible to be an Illinois not-for-profit corporation that is not a 501c3 organization. That is an absolutely valid and possible structure. It's becoming more common today, but it still is in the minority. But your 501c3 status, which is the piece that drives the tax benefit, that is a federal designation. Because it is a federal tax designation, the Internal Revenue Service is the primary regulatory body here. When you think about 501c3 compliance, we are thinking about compliance vis-a-vis the Internal Revenue Code and the Treasury regulations and regulatory action that is going to come from the Internal Revenue Service. We see that in the applications for 501c3 status. When you're a brand new organization and you're applying for 501c3 status, you do that by filing an application with the IRS, and the IRS exercises its regulatory authority to determine whether or not that applicant actually meets the 501c3 rules. On the reverse, it's the IRS exercising its regulatory authority when it revokes or seeks to revoke the 501c3 status of an organization. Revocations come after audits. There is a very robust, detailed process in the Treasury regulations and in other documents that outlines how an audit works and how it progresses, and how an organization may, at the end of an audit, find itself in a situation where the IRS has recommended that the 501c3 status be revoked. So audits is the way that's probably the most typical way that we all think of the IRS kind of exercising its regulatory authority with respect to 501c3 organizations. Similarly, but on a slightly less intensive scale, the IRS can also conduct what they call compliance checks, which at least start off as a much lighter check, where they might send out a survey or a questionnaire to a whole group of organizations asking whether and to what extent they engage in some kind of potentially problematic activity. You have to answer those accurately and completely. And depending on your answers, it may or may not lead to an audit. But when we think of, again, how does the IRS really regulate and oversee the 501c3 world? Once an organization has been approved by the IRS for 501c3 status, the IRS exercises that authority via its compliance check and audit and revocation abilities. Now, this is not the focus of today's call, but I do just want to emphasize that there's been a lot of talk lately about, can the president revoke 501c3 status of an organization? Can somebody decide, I don't like Harvard. Harvard, I don't think is operated for 501c3 purposes. I'm the president. Harvard is no longer a 501c3 organization. The answer to that is no. And there are laws in place and laws on the book that make clear that the president does not have the authority to just revoke somebody's 501c3 status. The way that 501c3 status is revoked is via a full audit by the IRS. And as you can imagine, in an audit process, there are a number of kind of forks in a road where an organization could decide to just accept the revocation or dispute it and escalate that higher and higher. But again, not today's topic, but I did just want to point that out because I know that that's been a topic of discussion lately. When the IRS audits an organization looking at its 501c3 status, what they're looking for typically is to see, are you satisfying the basic requirements to be a 501c3, to qualify for 501c3 status in the first place. The first is that you have to be organized as a not-for-profit corporation. There are a few limited exceptions here, but that's generally speaking what they're looking for. Do you have articles of incorporation in the state of Illinois or some other state where you are created as a not-for-profit or a nonprofit, or in some states, a non-stock corporation? That's what they are looking for. No individual should have an ownership or equity or shares in your organization. There are no owners. You are a nonprofit. They then also are looking for confirmation and documentation that not only are you organized that way, but you are operated for exclusively religious, charitable, scientific, testing for public safety, literary, or educational purposes. You may be asking, what is that list? Why are you giving me that list? This list in this presentation, this comes directly from the Internal Revenue Code. This is what Section 501c3 says. So when they are looking at applications for exemption and when they are doing audits, what they are looking for is they're looking to see is the stuff that this organization is actually doing on a day-to-day basis, is the stuff that this organization is operating to do, does it fall within one of these terms? Is it one of these terms? This is obviously not a completely robust list when we think of the types of things that charities do, but generally speaking, specifically speaking, you need to be able to really trace the things that you do on a day-to-day basis to one of these specifically enumerated purposes. That in many cases is very, very easy. In other cases, it's a little bit more challenging. And when you are an organization, especially one that has been around for 50 years, 100 years or longer, and your programs have changed and evolved over time, it's not always, doesn't always feel natural to kind of stop and say, let's evaluate what is it that we are doing? How does this fit within the 501c3 rubric today? This is a good opportunity to do that, to take a look at your programs and your operations and work with your advisors to just see, like, is this stuff, do we still feel reasonably good that this fits within the 501c3 rubric and it's one of the specifically enumerated purposes? That would be an especially helpful exercise to go through now, so that if in the unfortunate event your organization was faced with an IRS audit, you've already done that work and you're already in a position where you can speak with confidence to the agent. I mentioned this earlier, but other things that they're looking for, no part of your net earnings can be shared with any private individual. Nobody has an ownership stake. Nobody gets to share in your profits. That's not permissible as a 501c3 organization. No substantial part of your activities can consist of lobbying. We'll get to this in a minute. If you're a private foundation, no lobbying, period, none. If you are a public charity, you can do some lobbying so long as it's no substantial part of your overall activities. And then they also, especially in this current political environment, are going to be very focused on the prohibition, absolute, full stop, no de minimis exception, prohibition. No 501c3 organization can participate or intervene in any political campaign activity on behalf of or in opposition to any candidate for public office. This is the third rail. This is an absolute full stop. If you are a 501c3 organization, you cannot get involved in any political campaign activity at any level of government. Not for the President of the United States, and now in Chicago, not for the elected school board members. not for older persons. You cannot be involved in opposition to or in support of any candidate in any election for public office. This is going to be an area where, to the extent the IRS has the resources to actually conduct audits, I think they're going to be focused on this a lot. Now, your organizations are not just pieces of paper that are filed with government agencies somewhere. You are organizations made up of people, and you are made up of people who care very deeply about our community and care very deeply about the political process. Your directors and officers, your employees, they do not check their First Amendment constitutional rights at the door when they accept a position with your organization. They are still absolutely positively permitted and encouraged to be engaged in elections and in the political process in their personal time. So your job as the organizational representative is to make sure that you have a good policy and a good practice in place to be sure that everybody who's affiliated with you knows that if they're going to be engaged in political campaign type activity, that it needs to be on public time or on personal time, not using your organization's name or title or resources. Spending the time up front now to get those policies in place is a really key compliance measure that would be very helpful in the event of an IRS audit. Real quickly, so in the 501c3 universe, once an organization has been designated as a 501c3 organization, it is automatically classified as a private foundation unless it can demonstrate otherwise to the IRS, unless it can get out of that private foundation status and become a public charity. This is important to you, and you want to know, you want to confirm, well, which one are we? Because if you're a public charity, if you're a 501c3 that is a public charity, you've got much more flexibility regarding your operations and practices. If you are a 501c3 that is a private foundation, you are subject to a much more significant regulatory regime with penalty taxes and restrictions. So it's very important that you know and that your board and your staff understand which one you are, so that you can identify the specific regulatory regime that applies to you and then operate in compliance with that. Talked about the lobbying and political campaign. Last thing for the 501c3, very speedy overview, is that 501c3 organizations, you know, everybody knows, well, they're exempt from federal income tax. They don't pay federal income tax on their income. And that is true, except for unrelated trade or business income. Sometimes people call this UBIT. The Internal Revenue Code does impose a tax on unrelated business taxable income of 501c3 organizations. This is income that is generated by an activity that is not core to the performance of your charitable purpose. Really extreme example, if you are a 501c3 public charity feeder company and you sell tickets for people to come in and watch the performance, that is considered related income. That is not going to generate income tax. If you are that same feeder company and you are running a coffee shop on the corner that's open like regular business hours and serves people walking down the street, that coffee shop is going to generate UBIT for you. That is not income that is core to your charitable purpose. If you are a 501c3 organization and if you generate earned revenue, make sure you're taking a good look at that to be comfortable with how you are classifying it. This is another area that when there is IRS audit activity, they often think of this as kind of low-hanging fruit. So make sure if you are generating revenue in your 501c3 organization, make sure you're really looking at that now, working with your finance people and your auditors, just to understand your position on that and to be comfortable and confident in the position that you've taken. It was a really fast overview of some key 501c3 compliance issues. I just want to shift briefly to Illinois not-for-profit corporations. So like I said, the 501c3 designation, that's a federal designation. There are many, or I shouldn't say many, there are some and a growing number of Illinois not-for-profit corporations that are not-for-profit corporations. They are non-profits, but they have not applied for 501c3 status, and they may never apply for 501c3 status. So all those 501c3 rules that we were just talking about don't apply to them. But the Illinois law still applies to them. If you are an Illinois not-for-profit that also is a 501c3, then you are dealing with both sets of laws. In Illinois, not-for-profits are subject to the Illinois Not-for-Profit Corporation Act. You're also subject to some charitable trust and charitable solicitation acts. In Illinois, the Illinois Attorney General's office is the primary regulatory body over nonprofits and charitable organizations in the state. They take their job very seriously, and they really do kind of step into the shoes of the public to be sure that charitable assets are being protected and are being used in an appropriate and prudent manner. They have very broad oversight over nonprofits and charitable organizations in Illinois. They look at things like fiduciary duties, conflicts of interest, compliance with your governing documents, fundraising practices, and the like. They can be very proactive in that they maybe read something online that doesn't quite seem right to them, and then they reach out to the organization and say, hey, we've got some questions. We heard about a new practice that you're doing, or compensation that you're paying, or what have you, and we'd like to know a little bit more about this. They also sometimes respond to tips that they get. People call the AG's office a lot to complain about nonprofits and their practices. They have a very good, I think, filtering system for, what is, what's valid and maybe not what's not as valid, but they do take those calls seriously, and they're known to follow up on some that they think have some meat and substance. So in Illinois, when you're thinking about who might we hear from in terms of a regulator, who are we thinking about in terms of our compliance practices, in Illinois, it's the Illinois Attorney General. A couple related points, because 501c3 status, like I've said before, it's a federal tax designation, but local taxes are separate. So just because you're a 501c3 organization, you're not exempt from property tax. You're not exempt from sales tax. Those are local designations and local exemptions. If you are a 501c3 organization that owns property or that's buying a lot of things and you want property tax exemption or sales tax exemption, you need to apply for those separately. And you also, as a practical matter, need to be prepared that you might not get them, because we have found it harder to get property tax exemption and sales tax exemption in Illinois than 501c3 exemption from the IRS. But if you don't have these exemptions, you need to be sure you are paying those taxes, because there is nothing that exempts you from them. And this would be a very unfortunate and easy compliance miss. Similarly, kind of standard laws continue to apply. You're subject to all of the basic, minimum wage laws, employee protection laws, payroll tax, local business licensing. You don't get out of all that stuff just by being a 501c3. It might make some of it a little easier to deal with, but you still have to comply with all those other standard regular laws that apply to employers, even those that are taxable. So what we just talked about, I think, helps kind of start to set up when we think about, regulatory framework, where might we be seeing risk? If there is risk, who's going to be calling us? Who are we worried about? There's a couple different bodies here. We would have said for years and years and years in Illinois, it's the Attorney General. We have, like I said before, we have an AG's office that takes its job very, very seriously in this area. They are very active. So we always are mindful of the Attorney General when it comes to regulatory compliance and regulatory action. The IRS, of course, the IRS is the body that is going to be thinking about, or auditing your 501c3 status. They are going to look for things like the items that we touched on earlier. Specifically, are you still organized and operated for a charitable purpose? Are you meeting the basic requirements of 501c3? If you're a private foundation, are you complying with those taxes and the like? In the last year or so, we have added some additional sources of regulation or regulatory risk to our list. The first is under other federal bodies, other federal agencies, the Department of Justice chief among them. We have seen, really since executive orders were issued in January, at least a threat that the Department of Justice may be looking kind of across sectors for organizations that are engaged in what they deem to be illegal or improper activity. Illegal DEI, illegal racial equity, terrorism linked to immigration work. We're starting to see a growth in concern about investigations and audits essentially coming out of the Department of Justice. So that's another body that a compliance strategy needs to keep in mind. And then lastly, private party litigation. This is not one that really was active at all, or had any real practical weight to it until the Supreme Court's decision in the Harvard affirmative action admission case. Once that Supreme Court opinion was released and the Supreme Court's opinion was made public that affirmative action was unconstitutional because it was unconstitutional race-based discrimination, that reasoning and language directly from that opinion has been copied and pasted into a growing number of claims made against charities and nonprofits by private parties, claiming that a nonprofit or a foundation or some other 501c3 organization is unconstitutionally engaging in race-based discrimination in how it allocates funding or allows participation in its programming. They're growing in number, and they are also growing in, I would say, success for the plaintiffs. Not necessarily because they've been fully and completely litigated on the merits, but often because the charity or nonprofit that has been sued decides, weighing the costs of continuing the litigation against settling, has decided that it makes the most sense to settle and discontinue whatever program had been at issue in the first place. So this is another area where kind of strategically being aware of what's out there and what might be happening is really important. So with all of that happening, kind of swirling around in the background, like what do you do? What does an organization do? What does a mission-based organization that's working really hard every day to just do the work, what do you do? And while I can't, hand out a one-size-fits-all checklist, I think a good approach is to start with the basics. Get the basics right. In Illinois, you have to file an annual report every year with the Illinois Secretary of State. Make sure that happens. Get that done. Get your basic requirements done. Come up with a calendar that allows your staff and your board to know in what month are certain things due, when do they have to be filed, and make sure they get done and they get filed. So your annual report in Illinois is a really critical one just for compliance with the Illinois Secretary of State's office. With respect to the IRS and the public, your annual Form 990 and then its related AG 990 IL in Illinois incredibly critical. The fact of filing them and filing them on time is incredibly critical. But I would also add, this is not just a basic financial document. The 990, as many of you know and have seen already, it's a real blend of financial information and programmatic reporting. It is truly one of the most clear kind of guidelines or roadmaps to what the IRS cares about. Really read it, go through it in advance before it is filed, and make sure that you understand why you're answering yes to a question or why you're answering no to a question. If there's a term or a concept on there that you're not familiar with, ask about it. These forms are, not to sound too lawyerly, but these returns are filed under penalties of perjury, and they often are the jumping off point for an audit or an inquiry by the IRS. They are public documents, which is something that's different from personal or corporate tax returns. So they're public documents, which means that they are available for review and critique by folks who might not share the same values as your organization. Read these with a very careful, critical eye. Yes, absolutely, they have to be accurate, but make sure they're also telling your organization's story in the most thoughtful way possible in this current environment. Really look at them and understand what you are sharing with the government and sharing with the world in these returns. This next one sounds kind of simple, but it's not. Follow your governing documents. You have articles of incorporation, you have bylaws, and you have key policies like a conflict of interest policy. Read them. Make sure that you are still operating the way your articles and your bylaws and those key policies say you are operating. If you have evolved beyond what it says in your bylaws, maybe your bylaws say you have 4 directors and now you have 12. Make that change. You need to read what's in those governing documents, your articles, your bylaws, your key policies. And if you're not in compliance, you have to do one of 2 things. You either have to adjust your operations to get back into compliance, or you have to work on amending those documents to bring them up to speed with where you are. Worker classification is another kind of basic low-hanging fruit for the IRS and candidly for the Illinois Department of Revenue as well. Really look at who you're identifying as a contractor versus an employee and kind of pressure test that internally. Does that seem right to you? Are they really contractors or might they be employees? Get that stuff right. Work with your advisors if you've got any questions. Make sure that you're filing all payroll taxes on time, all your employment tax returns, getting all those things done on time. In years past, we might have talked about some of this as, footfalls, where perhaps we would think or hope that the government cared more about getting back into compliance than taking any kind of punitive action. I think we'd be making bad judgment if we thought that getting these wrong today would be treated just like football. Basics are really important. Just these kind of basic routine filings, deadlines, and the like are getting those right is a significant step toward improving your compliance. Conduct an individual risk assessment. Think about where your organization sits in this bigger universe. Organizations that receive or rely on federal funding, federal contracts, are in a significantly different risk position today than organizations that don't. And so what's material to them or what's significant to them is going to be different from what might be material to an organization that is not getting federal funding or federal contracts. Think about the work you do, your mission, the way you're talking about all of this, and think about whether the way you talk about your work and the programs that you run are they bumping into any of the issues that we know are vulnerable under this current administration? Are you engaged in, anti-climate change work, immigration work, DEI and racial equity, LGBTQ? Is your organization an advocacy organization? That's not to say these things are illegal, but it's to say that they certainly are areas that might cause a federal agency to kind of give your organization a second look if they run across if they were to run across you. If this is true for your organization, then the importance of doing the basic compliance check and really understanding specifically for your organization what rules apply to me and what don't becomes even more important. A couple of related concepts that I think are helpful and important. Many of your organizations have a record retention policy, or more appropriately described, a record retention and destruction policy. If you don't have one of these, work with your advisors to create one. What a record retention policy says is it lays out the kind of standard length of time for which you will retain all of your documents, all of your records, emails, documents, letters. And it says that after that period of time, you will destroy those records, except for, and in the case of litigation. If you are, litigation or some other investigation, if you get notice of, or that a lawsuit's coming or an audit's coming, you have to stop destroying records. But short of that, you should have as a routine practice kind of clearing out the files on a regular basis. Why does this matter right now? Well, it matters because if you get an audit request from the IRS that says, give me all of your minutes and records related to all of your board meetings. If you have those going back 30 years, you have to give all of them. And that means you have to spend staff time preparing and compiling all of them. And you have to pay a lawyer to look at all of them. If instead you had a record retention policy that says after 10 years, we get rid of things, then at least you have kind of cut off and limited the scope of the time and expense and attention that you have to spend. People hear all the time, it's not a joke, but the, statements about, drowning in documents and, overwhelming people in litigation. This is where it comes from, is the document production and the review of documents. So anything that you can do to work with your counsel to come up with a record retention policy that works, that's compliant with the law and works for your organization, is going to be a significant help toward your in compliance today, because it's going to limit the pain. It's not going to eliminate it, but it's going to limit the pain should it ever be activated. Make sure you have D&O insurance at a minimum, employment practices liability insurance, and then other insurance that might be appropriate for whatever programs you are running. But really look at those policies and make sure that you know what they cover and what's excluded. Keep your boards involved. It is hard to think of a time certainly in my professional life, where it has been more critical to be informed and to be nimble and to have good informed leadership from a board of directors than today. This is that time. Your boards need to be educated about what the environment is today. They need your help as staff to be educated about where the potential risk points and exposure points can be, so that the board can make an informed decision on where its risk tolerance is, how it wants to navigate these issues. It will do nobody any good if points of risk only become known when you get audited or sued. It's far better to be moving forward with kind of a broader appreciation for what your risk tolerance and risk profile is, than to find it out when it's almost too late. And then, of course, just continuing to stay informed about everything that is developing and changing around us, so that your organization can be nimble and can mitigate its risk accordingly. I'm going to open it up for questions in just a minute, but in closing, at least the more formal remarks part of this, I want to do two things. I just want to, obviously, like I said, there's not a checklist, a compliance checklist, but what really the compliance strategy starts with is kind of taking this information from today and then starting to think about, all right, now how does this apply to my organization? We are an Illinois not-for-profit, we're a 501c3, and we're also licensed by DHS. What does that mean? And work with your boards and your advisors to help really draft that out so that you can really understand what is expected of your organization by the various bodies that regulate it. And then you can craft your own unique compliance policy or compliance strategy around that. You're not on your own in trying to figure that out. Forefront and Chicago Lawyers Committee and others have been working and are continuing to work on really great resources for how to approach all of this, including opportunities to connect organizations with, with some specific representation and to help make those connections. What you really need is your organization really needs a lawyer or really needs a good auditor. Use those resources at Forefront and Chicago Lawyers Committee and others to help make those connections. And it's never too late to start. Like, a lot of this might feel very overwhelming. And in all honesty, a lot of this is overwhelming right now. And that's part of the design of this world in which we're living right now, is to be overwhelming and to be chaotic. But taking small steps toward knowledge and understanding of, all right, well, really, who are we in this universe of nonprofits? And what does that mean in terms of what we have to do? It's going to give you more confidence, and it's going to put you on, I think, stronger footing. So I'll stop there, and then I think we're going to turn off the recording and open it for questions.